The judge just said that they're appointing a guardian ad litem, and suddenly it feels like the spotlight is right on you. Are they here to take your child, decide who's right and who's wrong? Can they make final decisions? I'm Jeff Hughes, lead attorney and CEO of Sterling Lawyers. We have helped thousands of Wisconsin families navigate custody and placement cases involving a guardian ad litem from start to finish. In this video, I'll walk you through what a guardian ad litem actually does in Wisconsin, how the process works, and what to do and avoid if one is assigned in your case. What is a guardian ad litem? A guardian ad litem, also known as a GAL, is an attorney appointed by the court when custody or placement is contested. And here's what many people get wrong. A guardian ad litem doesn't represent you, nor does a guardian ad litem represent your child. The guardian represents the best interest of the child as determined by that guardian ad litem. They're not there to represent your wishes or your child's wishes. They investigate, gather facts, and recommend what they believe is the safest, healthiest, and most stable scenario for your child based on the evidence that they observe. So, what do they actually do? Once a guardian ad litem is appointed, they usually interview both parents, and that's often done separately, not together. The guardian will talk with the child, they'll visit homes, they'll look at the living conditions, they'll review school records, medical files, police reports if they're there, interview teachers, doctors, coaches, and other key people that are involved in the child's life. The guardians may also consult with or even hire outside experts like therapists or evaluators, and they may also attend mediation and other court hearings where they can file motions or requests just like any other party in your case. At the end of the process, they make a formal recommendation to the judge on custody, placement, and sometimes child support. And while the judge certainly makes the final decision, guardian ad litems carry a lot of weight in that final decision. We once worked with a dad, I'm going to call him George. He just panicked when he found out that a guardian ad litem was appointed in his case. He said, "I thought that meant I was already losing." No, we walked him through what to expect and helped him prepare and guided him through working and interacting with that guardian ad litem. In the end, the guardian ad litem recommended joint placement, and that dad went from 0 weekends to having his son half of the time. That's the difference that it makes when you understand the guardian ad litem process rather than fighting against it. Now, there are many common mistakes that parents make with respect to a guardian ad litem. First off, don't do these things. Don't ignore the guardian ad litem or delay in responding. Don't badmouth the other parent. Do not refuse visits or interviews, especially that. And don't assume that they are against you. Guardians are not looking for perfection, but they are looking for honesty, involvement, and maturity. If you become defensive, evasive, or hostile, that is what they will remember. A common question we get is, do I have to pay for a guardian ad litem? Well, yes. And most often it is divided between the two parents. The judge orders that. And guardian fees typically range to begin with between $1,000 and $3,000. And while the fees are most often split between mom and dad, sometimes when there is a big disparity in income, the judge may order one party to pay more of the costs or even to pay all of the costs up front and be reimbursed later out of the marital proceeds. And if both parties are indigent, meaning if they don't have the resources at all to pay a guardian ad litem, the county will then step in and make those payments. But those parents may be required to pay down the road. Another common question is, can I check in on what the guardian ad litem is doing? Yes, after 120 days, you can request a hearing to hear from the guardian ad litem on what's going on. But most commonly, it simply is a phone call to the guardian saying, "Hey, can you give me an update on your investigation into our case?" Now, once a guardian ad litem is appointed, what should you do? Always be respectful and responsive. Show how you are involved in your child's life and keep the focus on your child, not on your ex. So don't litigate the problems with your ex with the guardian ad litem. That is not their role, and they really most often don't care about that. They want to know what is going on with your child, what is in the best interest of your child. So keep your focus there. That is vitally important. And also provide all of the requested documents promptly or as soon as you can. And be clear Be calm. This isn't the time to vent with the guardian ad litem. I saw a case one time where the other parent ignored emails, ignored calls from the guardian ad litem, didn't return paperwork, didn't respond to almost anything. And when that court date finally came around, the guardian ad litem told the judge they simply didn't have enough information to recommend placement with that parent. So they recommended placement with the other parent and leaned heavily in all respects of the case. That is not how you handle a guardian ad litem. Be responsive, be respectful, be prompt when dealing with the guardian. And remember, you don't have to be perfect, but you do have to participate. You do have to be transparent and be honest with them. Let them know how much you care by your actions. And here's a kicker. Many parents, even if they are trying their best, sometimes make one of the three big monumental mistakes with a guardian ad litem. In this next video, I'll walk you through exactly what those mistakes are and how to avoid them in your case.